Well, thank you for being here. I'll take off my Denver Bronco mask because we are appropriately socially distancing. This is the first time I've given a presentation through a Zoom webinar, and it is odd to think that there is a couple hundred people out there listening to what I say in this room, but because people never listen to what I say. But anyway, I'm going to be talking about non-compete and employment agreements, and I have a short little PowerPoint presentation that I will use. And unlike Josh, I don't have very many words on my PowerPoint slides, but I don't think that's necessarily a virtue. I think I was just lazy, but hopefully I'll be able to explain some of these a little bit so that there'll be some good information that comes out of this. The general idea, I think, about non-competes in my practice, I've dealt with these somewhat regularly now for 25 years, and that there are to a lot of employers, oh, they sound good in theory, well, they just sound good to the employer. But in practice, there's always been some problems with them in terms of whether or not they work effectively as the employer intended. And that has gotten a little bit more pronounced in the last year because of Maine's relatively new statute that went into effect a little over a year ago that places greater restrictions on the ability of employers to use non-compete agreements. Just be mindful that it varies from state to state, and this was Maine's first real plunge into these waters. But in some states, they are much more restrictive things. So if you're an employer that does business in many different states, you'll want to be aware of that. Why is there a bullet that says $51,040? Well, the reason is that under our Maine statute, for this year at least, if your employee, if you have an employee that makes less than $51,040 for the year, you're simply prohibited from having that employee sign a non-compete. It will be unenforceable. And furthermore, you can be fined a fine of not less than $5,000 if you sign someone up there. Now, this law isn't retroactive. So if you have non-competes in place that were in place before September of 2019 that cover employees that make less than this, you're okay. But if you've entered into one in this last year or planning on it in the future here for employees who make less than that threshold, then that's a no-no. And it's indexed for inflation, and so that'll go up presumably some next year. The next bullet there, later of 6 months or 1 year, this is something I think that employers find troubling, because what this means is that if you have somebody sign a non-compete today, it cannot be effective to prevent the employee who might be a former employee by then. It cannot be effective for at least 6 months from the date the contract is signed, or for 1 year of employment, whichever is longer. So if you have a brand new employee and you jump through the right hoops and they sign a non-compete that is compliant with this statute, it still can't even be effective for an entire year. So if 11 months after it's signed, they leave for whatever reason, fired or they quit, it's not enforceable. Whereas if you have a current employee, for example, and they sign a non-compete, they've already worked, say, a whole year, 2 years for you, you still have to wait 6 months before that's effective. The next bullet, 3 business days, what that means is that you have to give the employee at least 3 business days to consider the draft non-compete that you want the employee to sign. And for new hires, if you're going to try to get the employee to sign a non-compete, you have to, prior to the offer of employment, give notice or tell the employee that you're going to ask the employee to sign a non-compete. And that one, if you run afoul of, that is also can be a fine of not less than $5,000. So that's sort of a problem, perhaps, because I can imagine many times when you're trying to attract a new employee, the first words out of your mouth aren't going to be, oh, and we want you to sign a non-compete. But if you get too far along the process there and make the offer of employment and then tell the employee, oh, and by the way, you'll need to sign a non-compete, you've now violated the statute. The statute also limits explicitly what it is the non-compete can protect. It can protect only the legitimate business interests of the employer. Listen, I am staring up here like there are people out there, but anyway. And the statute identifies 3 legitimate business interests that can be protected by non-competes. One is confidential information, not surprising. 2 is trade secrets, and 3 is goodwill. Yeah, before I went to law school, I had no idea what goodwill meant, certainly in this context. Basically, goodwill is a phrase that's used in case law, but also in when you sell a business, it's one of the things that often is sold. Sometimes it's referred to as going concern value, but in main case law, it means the probability that existing customers of the employer will remain customers. And that's the goodwill of the business. And so if you buy somebody's business, you want the goodwill so that when you buy the business, you get the customers that the former owner had. In any event, you can use a non-compete to protect the employer's confidential information, goodwill, or trade secrets. Now, Maine has something called a Uniform Trade Secrets Act, which already gives employers protection even without anybody signing a non-compete. And under the Trade Secret Act, trade secrets are defined as information that has economic value because it is not generally known or readily ascertainable by proper means by others, and is the subject of efforts that are reasonable to keep it secret. So you can have a non-compete agreement that says prohibits former employees from misappropriating or using trade secrets, and often it's in there. Almost everyone I've ever seen, there's something about that, but it's redundant because there's already a statute that protects that. And also there's a little known fact, I suppose, under the common law, that means it's not a statute, it's just case law that comes from now over 100 years in Maine and other places. A former employee is not permitted to use confidential information obtained through that employee's employment against the employer after the employee leaves the employment. And it's often comes under the rubric of unfair competition. And it just means that, for example, an employee of Redmond and Winchell can't, while employed, if that employee is privy to certain truly confidential information, can't then quit, go across the street, and then use that information to compete against Redmond Winchell. Now, of course, they can. It just then Redmond Winchell could then, if it wanted, try to sue that former employee on the basis of the common law, even if there were no non-compete agreement out there. The last bullet here is costing me money versus unfair competition. I often see situations where there is a non-compete and the employer comes to me and they're livid and they want to, put the hammer down on this former employee who's out there competing and taking clients away from them because that former employee is costing me money or costing us money. But when you strip away what the statute says, what the common law says, what all this stuff says, what it really gets down to is the question isn't whether the former employee is costing you money. It's whether or not the former employee is competing unfairly with you. And by unfairly, that's a common sense sort of notion with an objective, unbiased third party who hears all the facts think that there was just something unfair about what the employee was doing and former employee. And if it's not unfair, then it's just, hey, it's free market. It's what we do in America, free enterprise. And so your chances of succeeding in enforcing it, especially under the new statute, are slim. Part of the problem with the new statute is that it has a definition of a non-compete agreement in it. And so if the particular agreement that you want the employee to sign doesn't fit that definition, it's not even subject to this statute. And I probably unfairly, I criticize legislators too much, I suppose, because they draft these, I've got 5 minutes, they draft these laws and it's so difficult to understand what some of them mean. And in this case, especially, I've read the definition of non-compete in the statute many times, and I'm not really sure what it means exactly, but I've given examples here of what it probably means and what it doesn't. The next slide is obstacles to enforcement. Yeah, as an employer, you may be upset, you want to put the hammer down on the former employee, but we live in a relatively small community and you really do have to think about how that's going to make you look. The $10,000 to $40,000 is a conservative estimate of how much the legal fees would be to go out there and put the hammer down. And even if you win, a lot of times there's a fee shifting provision in the contract, but good luck trying to collect after you, quote, win. And in these, at least in reported cases and in the cases I've been involved with in litigation, the facts are hard to prove. They just are. It's very fact intensive, and that makes litigation more expensive when there's lots of facts, lots of witnesses. So the conclusion is for non-competes, one form most definitely doesn't fit all. They're more difficult to write now than ever before, more difficult to put into place, more difficult to enforce, but they're still worthwhile in some situations. Now, in my remaining 2 minutes or so, I'll talk a little bit about employment agreements. The first thing to keep in mind is that there are as many different types of employment agreements as there are types of employment, and there are a lot of different types of employment. And so when somebody calls me up and say, oh, just give me your form employment agreement, I go like that because there is no such thing. It depends on the type of employment. Certain professions usually have them. I put them down there. They won't shock you. Physicians, dentists, eye doctors, etc. High-ranking academic administrators like chancellors, for example. Certainly publicly traded company executives. Commissioned salespeople almost always do and have some sort of contract because their compensation can be very complicated sometimes. Former owners of small businesses who sell their business. I got a business, I sell it to Anne Marie, but I want to stay on for a couple years. And so we enter into a contract where basically I don't have to do much as the former owner, and I still get paid, and she promises to pay me.
She's not going to.
Yeah. Now, there's a litany of stuff to consider in employment agreements. They're not shocking. Certainly the term of the agreement, term of the employment, you can still have at will. The contract can specifically still say you're an employee at will, can be terminated with or without cause, so forth. The agreement says, well, what will terminate the employment? Disability, will it be just for cause? That's, where the employee does something naughty. Then you have to think about how you define for cause. Usually, for whatever reason, it's if the employee does something wrong, they get terminated for cause. If the employer does something wrong, the employee can terminate the contract for, quote, good reason. But other things to deal with are ownership of intellectual property rights. Almost always the employer retains exclusive ownership of any copyright, trademark, patent, etc. Though not always, and that can be a bone of contention. You want a non-compete, non-confidentiality or confidentiality agreement. Benefits, things like vacation insurance, deferred compensation can get very complicated very quickly with tax issues. I usually, again, that's something where in theory it sounds like a good idea, but in practice it can lead to all sorts of issues. And of course, compensation, most not shocking, the litigation or disagreements I've seen in the end are about compensation. Somebody thinks they were entitled to more than they got. Bonuses are very, I see formulas, to calculate bonuses, and I have no clue what they mean. In other words, my client hands me this, say, well, we've agreed upon this formula, and I read it, and I just, holy cow, I can't understand what this means. Does my client and the employee understand it? Even then, it should be rewritten probably. Dispute resolution language, duties and responsibilities of the employee. Moonlighting, is the employee permitted to work elsewhere or not? Expenses, do they get to, how for their out-of-pocket expenses, what do they get reimbursed for? This comes up more than you might think. Where are they going to work? They don't want to work somewhere else. They want to stay there. I've now got the hook, which is, but it was a very, very kind hook. So I will bid adieu. This was, after all, the first rapid fire of phase 2, part 2.
Second rapid fire.
Second rapid fire. So now we'll go to the second of the second rapid fire.
Just sit down.
Speak about wage and hour matters. Thank you.